Kieran Pender. I'm a senior lawyer with the Human Rights Law Centre, leading its work here in Australia on whistleblowing and whistleblower protections. I'm really delighted today to be presenting this webinar to mark National Whistleblowing Day with a webinar that's going to focus on whistleblowing and whistleblower protections in Australia and some of the international intersections of that. Australia is a country that at one time was at the forefront of whistleblower protections in many respects, and is currently facing a number of challenges, but also opportunities. So we'll be unpacking those today. And I'm really delighted to be joined by two of Australia's leading experts in this field. We've got Professor AJ Brown at the University of Griffith, effectively synonymous with whistleblowing in Australia and whistleblower protections. I think has been involved in designing pretty much every whistleblowing law we have here in Australia. AJ is also on the board of TI, Transparency International, both international and in Australia. Also joined by Rebecca Ananian-Welsh, a senior lecturer at the University of Queensland with expertise on whistleblowing and national security law and press freedom. And both good friends of mine, and delighted to be having this conversation on an early Australian morning. So let's get into it. AJ, do you want to kick us off? What do you think is the state of play at the moment on whistleblowing and whistleblower protections here in Australia, and how does that compare with the international developments?
Yeah, thanks, Kieran. And I think you hit the nail on the head when you said that Australia has been at the forefront of whistleblower protection law internationally at times. I think it's worth people remembering that Australia was pretty quick, especially at a state level in our federal system, to introduce whistleblower protection laws for public servants in government right from the early 1990s. But it took quite a while for the federal government to catch up, and it wasn't until 2013. And then again, we've sort of leapt to a little bit to the forefront just as recently as 2019 with the first laws internationally introduced in Australia for corporations, for the business sector, that the first laws that anywhere in the world that actually required all significantly sized companies to have comprehensive whistleblowing policies, as well as the other legal protections coming into play in a much more comprehensive way. And that was ahead of the European Union directive, for example. And then also the first country in the world to actually introduce penalties or liability on employers who fail to prevent detrimental action against whistleblowers. So rather than simply waiting for reprisals or detrimental action to occur, it was the first law in the world to actually make employers potentially liable if they fail in a duty to prevent detrimental action. So those have been some pretty significant developments, and I think what it shows is that it's well established, well accepted in government, but also in business, that good practice, good governance includes good whistleblower protection. But that's sort of all still in principle. We know from our research that at least around 40% of whistleblowers end up still saying that they were treated badly by management or by their co-workers, usually by their management. And that's too high a percentage. And the rubber really hits the road when these laws have to be implemented. And that's where, like much of the world, it's an ongoing challenge and a serious one.
And how do you think, AJ, things currently stand compared to some of our international counterparts? And I'm cognizant of the EU directive and the impetus that's been given to these issues in the EU. Do you think we stack up?
Well, I think we're a little bit ahead in some respects, like with, for example, that liability for a failure to fulfil a duty to prevent detrimental action. But we're also a bit behind in other respects. The remedies, actually getting the remedies for detrimental action for whistleblowers in Australia, there are lots of hoops and tricks in the laws which shouldn't be there, lots of little barriers. And so reform to bring our public sector laws sort of up to par with our private sector laws and make sure that they match or exceed the sort of standards set by the European Union directive, and learn properly from some of the experience in the US and elsewhere. That's still an ongoing challenge.
And I appreciate at the end, we're planning on coming to the solutions and what we see as the changes that are necessary. But is there sort of one particular challenge you'd like to identify that faces us in Australia in terms of improving our whistleblower protections? What's the one thing we need to do?
Well, I think where Australia really falls down quite spectacularly, we can clean up a lot of small defects in our laws, but where Australia really falls down spectacularly is in terms of knowing how to protect people who go public at the end of the day, when that's justified. And we know from experience sometimes that will always be justified, and that's a good thing. But we've got a number of prosecutions underway at a federal government level into whistleblowers at the moment that for not having blown the whistle internally, but for having blown the whistle externally. And when that happens, very often that's where it becomes really challenging. At the end of the day, organisations still don't like, and especially governments still don't like, having stuff revealed publicly that's embarrassing, even when we know, we all know at the end of the day that people have basically followed the rules and tried to blow the whistle internally first, and it apparently hasn't been dealt with properly. So fixing those rules so that we have effective protection at sort of all three tiers, internal, regulatory, and external or public, is definitely a big part of the mix.
Right. That's a great segue to what I wanted to touch on. But I just had one last question for you, AJ, which is, when you're engaging with the corporate sector in Australia, I mean, we've talked and we will talk about the public sector whistleblowing, but what's your sense of whether corporate Australia is embracing whistleblowing law and whistleblower protections?
Well, I think when it comes to corporations and the private sector, it's a mixed bag. There's a huge range between companies that take it seriously and are really trying very hard, especially in our financial sector, for example, even in the resources sector, but through to companies and employers who have never even thought about it and have no clue whatsoever. So we know that it's a really mixed bag. The new obligations in Australia only began just at the beginning of the COVID pandemic. So I think there's been a lot of distraction, but there's signs that our corporate regulator is reminding people that those rules are there. But I think the key thing is that there's a lot of support for good practice. There's a lot of support for the new international standard on whistleblowing management systems that many people around the world have been involved in, which is due to be finalised by the ISO and published very soon, for being able to have clearer guidance to set up good whistleblowing management systems in an organisation. Many companies simply don't know how to do it. They know how to encourage people to blow the whistle. They don't know how to protect them and support them when they do. And that's really part of the cutting edge now, I think, of preventing a lot of that damage, which is quite preventable.
Fantastic. Thanks, AJ. So AJ touched on some of the prosecutions, and I wanted to briefly talk about that. At the moment in Australia, we have, we had, as of this month, 4 whistleblowers on trial for speaking up about wrongdoing, public wrongdoing, wrongdoing committed, either proven wrongdoing or alleged wrongdoing by our government and its emanations. I say was because just recently one of those whistleblowers, a former intelligence officer known as Witness K, was sentenced to a suspended 3-month term of imprisonment. But we still have 3 whistleblowers on trial. And I just want to briefly talk about those cases because I think they go to one of the core challenges that AJ sort of hinted at. So right now we have Beirne, who's an Australian lawyer who was acting for Witness K, and is alleged to have provided information about wrongdoing by Australian intelligence officers against Timor-Leste to the media. We have David McBride, a former Australian Army a lawyer who spoke up to the media about war crimes allegedly being committed by Australian soldiers in Afghanistan. And we have Richard Boyle, a tax office whistleblower who spoke up about aggressive and unethical debt recovery practices being pursued by our federal taxation authority. In all three cases, it's widely accepted that they spoke up about wrongdoing that was perpetrated, that has subsequently been vindicated. Independent reviews have agreed with Boyle about the debt recovery practices. A really landmark independent review has found significant wrongdoing, alleged war crimes by Australian forces in Afghanistan. Although the Australian government refuses to confirm or deny, it's widely accepted that Australia spied on Timor-Leste in negotiating an energy and oil and gas treaty, and that treaty sometime subsequently was renegotiated to reflect that. And yet these three Australians are currently facing jail time, quite significant jail time in some of those cases. And I think it gets to sort of two core issues. And the first is the politicization of prosecuting whistleblowers. We're in this very unfortunate situation where a number of these prosecutions required the consent of our Federal Attorney General to proceed, and that has arguably politicized these prosecutions in a way that makes it very difficult for our Commonwealth Director of Public Prosecutions to back down. And that's a real pity, because it's certainly the Human Rights Law Centre's view that prosecuting whistleblowers is not in the public interest. Under our prosecutorial regime, we have independent prosecutors, and their remit is to prosecute in the public interest, and they retain discretion up until the point of trial in discontinuing proceedings that are no longer in the public interest. And so the Human Rights Law Centre and other like-minded bodies and a number of federal parliamentarians as well have called on the Commonwealth Director of Public Prosecutions to drop these prosecutions. It's our view that there's no public interest, and the chilling effect that prosecuting whistleblowers has is significant and deeply problematic in a democratic society like Australia's. And yet, unfortunately, there seems no sign that those calls are yet being heeded. These prosecutions march on. They've been very complex. There's a layer of secrecy that shrouds them, which Rebecca will talk about in a moment. And there's been a number of interlocutory steps along the way. But we're getting to a stage where the tax office whistleblower Boyle will go on trial in September. The whistleblower defence of the war crimes whistleblower McBride will be heard in September, and Cleary, the lawyer, his matter will likely go soon before our High Court on an interlocutory issue of the secrecy. But so we have this ugly stain on Australia's reputation in terms of whistleblowing, that rather than protecting our whistleblowers, we are prosecuting them. And that is particularly alarming because, as we'll touch on later, our federal whistleblowing law is in need of reform. That's reform that has been urged on the government and hasn't been followed through. And so simultaneously, as the federal government in Australia has been told that our whistleblowing laws are not working and need to be fixed, we have a perverse situation where rather than fixing them, they're prosecuting those who sought to speak up under them. Again, it's our firm view that that's not in the public interest, and the chilling effect that's having on Australian whistleblowers is really troubling and significant. They also point to this broader issue of how to encourage people to lawfully speak up in a manner that's going to be protected when it comes to speaking up to the public. As AJ highlighted, and I just want to drill down on that particular issue. Our federal whistleblowing schemes are not good in the way that they enable external emergency public media disclosures. There's a layer of complexity in both the public sector and private sector schemes that makes it extremely difficult to comply. I was just last night looking at our federal private sector whistleblowing laws in the Corporations Act, and to speak to the media or to speak to a politician about your disclosure, you have to jump through so many hoops that it is extremely difficult for a whistleblower to comply with that. And there's often also the risk that they don't actively seek to comply because there's a lack of support for whistleblowers, and then subsequently in a position where they're trying to rely on it, but they can't because they didn't jump through those hoops. Now, of course, hopefully in the future, they'll more actively seek out earlier support, but even when they don't, the lack of a broader public interest defence is extremely problematic. And so we're seeing that in all three of these cases. We had these whistleblowers eventually go to the media. In the case of David McBride, for example, he did try and raise it internally. At least that's my understanding. As I said, a number of the facts in this matter are subject to secrecy. But I think it's common ground that he tried to speak up internally. He tried to speak up to various external authorities. And it was only then that he went to the media. A fairly clear-cut example of someone doing the right thing. And yet our laws are not adequately protecting those in that final stage. And so I think a key reform ask, and we're going to touch on later, reform period, is the need for better protections. And I think one challenge we have here is Australia, unlike the United States, does not have a robust legalistic free speech culture. We don't have a First Amendment equivalent. And so perhaps the American approach to a number of these things around the right to speak to the media informed by the First Amendment is not something we have here in Australia. Perhaps more on par with the European approach, but even then we lack the same human rights protections available to European whistleblowers. All of which is to say that it's not easy for whistleblowers to speak up publicly in circumstances that should otherwise be permitting them to do so. And that leads to this perverse situation where Australia currently has 3 whistleblowers on trial. So I wanted to hand over to Rebecca now, because as I mentioned, these prosecutions, at least a number of them, are being held predominantly in secret, which raises even further issues. So Beck, over to you.
Thanks, Kieran. I think before looking at the secrecy around these prosecutions, it's worth just underlining one of the things you said again, because I've always encountered when I speak to an international audience some level of jaw-dropping and shock that goes on around the simple fact that Australia has no national human rights protection in the form of a bill or even a charter of human rights. So yes, that means that there's no First Amendment, there's also no due process clause, there's no mention of press freedom, there's no mention of, there's no Bill of Rights. Yeah. Now that gives the government almost unlimited power. There are some implied, but they're thin limits to encroach on what we all consider to be fundamental liberties and even on democratic rights. Now, at the same time as we have that unique amongst Western liberal democracies lack of strong protection or even recognition of human rights, in the 2 decades since September 11, we've also seen exactly the same trend that you've seen around the world towards secrecy, towards surveillance and increasingly mass surveillance. And well, the last count I heard, there was 90 counter-terrorism laws enacted in Australia since 2002. So that's more than anywhere else in the world. Kent Roach in Canada called it hyper legislation, and that's spot on. So we've had more national security law than anywhere else in the world. That's a trend towards greater government power alongside a trend towards greater secrecy. So that's the context. One of the important kind of contexts in which these whistleblowing protections and whistleblowing instances are happening. So when we try to understand what's happening here, where whistleblowers are being prosecuted, and those prosecutions are happening with various degrees of secrecy, a lot of that is plugged into this broader national security framework. So there's something called the NSI, what we call the NSI Act, the National Security Information Act, introduced in the years not long after September 11, so 2004. And that act, the point of it is to allow governments to protect national security information. National security there is defined very broadly. So protect sensitive information by relying on it as evidence in court, but maybe the other side doesn't see it. The other side probably won't see it. The jury may not see it. The judge may be the only one to see it. That act can provide for anything from the redaction of names, which no one would have much problem with, right up to closed courts, or as we've seen in the Witness J scenario, completely secret trials. We didn't even know that that trial had happened, that anyone had been charged for some years, until almost by accident it was revealed. So when we have whistleblowing coming out of government, often that involves classified documents, secret information, things broadly about national security. Alleged war crimes by Australian soldiers certainly comes under that. Witness K was an intelligence officer, blowing the whistle on an intelligence operation that contravened international law. So that's the kind of reason why we see secrecy coming into this. Things that were justified on the basis of kind of terrorism are now being used to stifle public knowledge, and even things like fair trial rights for whistleblowers. There's a whole lot that's disturbing about this really disturbing framework, that, again, to go back to our lack of human rights protection, doesn't have the incorporation of things that you see elsewhere in the world, like special advocates and giving the gist of the information and things like that. That's absent, or can be absent, in Australia. There's impacts, obviously, on democracy, on open justice, on fair trial rights. But one thing I think that I'd like to mention is that this secrecy is happening as part of a crackdown on the broader chain of disclosure. So it's not just this prosecution of whistleblowers and the reprisals on whistleblowers, and that can happen in secret, but that this is part of a broader crackdown on information generally. And the moment, I think, when we really saw that come to light was in June 2019, where the Australian Federal Police, over the course of 2 consecutive days, raided first a News Corp journalist, Annika Smethurst's home in Canberra, and that was specifically seeking information that would identify a whistleblower who had come to her with information about our military intelligence agency potentially getting new powers of domestic surveillance. And then the very next day, we saw another kind of daylight raid on our national broadcaster. This time it was seeking information around David McBride's leaking of information to the journalist Dan Oakes about those alleged war crimes by Australian soldiers in Afghanistan. So these were shocking daylight, jackbooted kind of raids, with journos live tweeting as Annika Smethurst's underwear drawers were gone through, or thousands of files at our national broadcaster, the ABC, were collated by AFP officers, all for the very targeted reason of going after the sources, of going after the whistleblowers. Did that mean that the journalists were safe? Absolutely not. So at first, the AFP compiled the investigation against Annika Smethurst was only dropped recently. Dan Oakes was very much on the line to be prosecuted for, of all things, basically receiving stolen goods, receiving stolen Commonwealth property in the form of the information that David McBride had leaked to him. That brief of evidence was prepared, and it was only because the Director of Public Prosecutions said it wasn't in the public interest. That wonderful public interest test that Kieran mentioned that can kind of flexibly go one way or another, thankfully here weighed in favour of not prosecuting a journalist for telling the Australian public about something that was definitely in our interest to know about illegal conduct by our soldiers. But just because those investigations didn't go anywhere doesn't mean, and this is something we found in talking to journalists across Australia, that journalists feel safe themselves from prosecution or feel like they can really give any reassurance to their sources who are these whistleblowers who are coming to them, or include those people. Quite the opposite. I think journalists are feeling targeted by government laws and by police investigations, which could be as overt as a daylight raid, or it could be covert in the form of data surveillance. And we have huge kind of sweeping powers for covert data surveillance, including of journalists, including to target their confidential sources, because we have no real protection for press freedom or free speech or anything around that in this country. So it all tends to come down to investigatory discretions, decision making that's going on within the police force, and then eventually prosecutorial discretion. And that can go either way. It could lead to something being dropped, as it has been with respect to Dan Oakes and Annika Smethurst, or it could lead to these secret trials that we've seen with regard to Witness K, David McBride, Richard Boyle. So when we ask ourselves if we could be seeking something as I say crazy, and that's probably right, but something as shocking as secret trials of journalists, as well as secret trials of whistleblowers in Australia in even the near future, it is a very real possibility here. And it's one that people are changing their practices around, practices from dealing with sources, but also what stories to publish and what not to publish, when to talk to a source and when not to talk to a source, whether to actually run a story a whistleblower wants you to run with. Those are decisions that are being made on a daily basis in this kind of high risk environment.
It all leaves you feeling a bit grim, doesn't it? But I think the three of us are here because we're optimists, and we think and we hope that doesn't have to be this way. So we're going to conclude with each of us offering a recommendation as to how do we address these challenges. You know, what does the future look like? AJ?
Yeah, I think it's really important. I mean, the description you've just given, Beck and Kieran, about the challenges we face at the moment is totally accurate and spot on. But I think it is really important to see these things in the full scope of history. It's the sort of things that we're seeing are actually seen quite regularly in quite a lot of countries at the moment, and also historically. And what's surprising is that a country like Australia has sort of ended up in this situation almost by accident, but that doesn't excuse it, and that doesn't change the fact we've got to do something about it. But it's almost by accident, without realizing. It's like a boiling frog syndrome. Without realizing it, we've ended up in a situation that we don't realize how bad it is and how much we don't want to be here as a country. And I think policymakers in Australia need to wake up to that. We actually see these things come and go in waves. And I think it's almost like our politicians, even though they're fighting to preserve national security and are actively increasing these secrecy challenges unnecessarily, are at the same time very embarrassed when it's not every government agency, it's particular government agencies go to war against journalists and whistleblowers, and then it turns out that our independent prosecuting authorities and our politicians are almost taken by surprise. How did it get out of control like this? And then we don't know how to rein it back in. And I think that's part of what we're seeing with this particular latest wave of prosecutions. So we need law reform to rein it back in, so that it doesn't become a matter of political interference and political discretion to say who should be prosecuted and who shouldn't be. So we need to learn those lessons. We need to reform our legislation in a number of ways, but in particular, as you were saying, Kieran, to recognise and Beck, to recognise that national security or intelligence information in and of itself should not automatically trigger exclusions from whistleblower protections, which is currently the effect of the legal definition of what intelligence information consists of under our federal whistleblowing law, the Public Interest Disclosure Act. If it's ever been anywhere near an intelligence agency, it doesn't matter what it is. If it's been anywhere near an intelligence agency, then it's basically sort of systematically excluded, certainly from public disclosure. It doesn't matter how bad it is. Doesn't matter, and that's, I think, seen in a number of countries, and it doesn't need to be that way, and that definitely needs to be reformed. But I think we know that in principle, the role of whistleblowers and the role of media is still well recognised and understood in Australia, in Australian society, by politicians. What we need to do is to continue to wake people up to the fact that we're in a place that we didn't expect to be in and we don't want to be in, and that it's going to take some serious reform to get back to actually being the country that we thought we were.
Thanks, AJ. And the good news is that there is currently a reform window. The federal government has committed to reforming the Public Interest Disclosure Act, which is our federal public sector whistleblowing law. So hopefully we'll see some of those changes soon. I think for my part, I want to highlight the need for more support and practical support for Australian whistleblowers. You know, AJ and others for the last several decades have done an incredible job giving us the legal framework that protects whistleblowers. And we need to continue to actualise that. You know, the Human Rights Law Centre has looked at whistleblower case law in Australia, and there are very few cases. And when the cases are brought, almost always the whistleblower is unsuccessful. And that reflects, you know, yes, there's some legal things that can and need to be tweaked, but more fundamentally, it reflects a lack of support. So the Human Rights Law Centre, among others, is committed to doing more to supporting Australia's whistleblowers at a really practical grassroots level, you know, with litigation, etc., and then using that knowledge and insight to continue to improve via law reform and advocacy and policy. So we hope that will be a virtuous circle. And so I'll give Beck the last word.
I guess I'd echo AJ on the exclusions. It's such a big deal to just have that complete carve out. You are not protected by whistleblower protections, full stop, if this kind of stuff is involved. So to just revisit the scope of those exclusions and really think about whether they're absolutely necessary. Looking particularly at intelligence whistleblowing, I think shoring up those internal avenues of disclosure as well as the external ones, but starting with internal, both David McBride and Witness K tried to do this like properly internally. They thought they were doing the right thing, and those internal avenues were just inadequate, too narrow and not able to address the actual issues, which were very real in both of those instances. So improving even internal avenues of disclosure, which I think is an easy win for government, that no one's got to know about it. But then looking externally, I think that full chain of disclosure needs to be looked at, from how information gets from inside government, particularly, or inside even these powerful organisations, to the public. So it's not just about whistleblower laws, it's about source protection from the press freedom kind of angle. It's about press freedom at all. And at the other end of my spectrum of, you know, easy wins and hard wins, I would love to see some human rights protection in Australia. I think when you look at this kind of issue, you realise that it's not just one right or liberty that's at stake, like freedom of expression. It's democracy, it's fair trial rights, it's open justice, it's a whole range of different things in play. And the total absence of something bringing all those together and putting them on the table is really problematic here. And I guess lets us slide away from where we think we are, which is this really strong rule of law, rights respecting nation, into completely secret trials that nobody knows are going on and nobody's able to really take a hard look at. So easy wins and hard wins there, but I think it all should be on the table.
Fantastic. Well, thank you so much, Rebecca, AJ, and a happy National Whistleblower Day.